This is Antonio Gangale. This is part 2, discussing the United States of America versus Union Cheese Company. Within this matter, the court asserted that it had jurisdiction over the subject matter and of the parties. Additionally, within the findings of fact and conclusion of laws, it states, having considered the testimony of the witnesses, trial exhibits, the memorandum supported on behalf of the parties, arguments of counsel, and the applicable law, the court makes the following findings of fact and conclusions of law. Requisites of a valid judgment. Before a court properly may undertake an adjudication, 3 requirements must be met. First, the person whose interests are to be adjudicated must be given adequate notice of the proceedings and the opportunity to be heard. Third, the court must have authority to adjudicate the type of controversy presented to it. This authority is generally referred to as subject matter jurisdiction. Failure of any of these requirements is a ground for objection to the maintenance of the proceedings in the court which may be brought. Subject matter jurisdiction. The definition: power of a court to adjudicate a particular type of matter and provide the remedy demanded. Judgments entered where a court lacked either subject matter or personal jurisdiction, or they're otherwise entered in violation of due process of law, must be set aside. Subject matter jurisdiction elements: jurisdiction over the parties, jurisdiction over the subject matter, jurisdictional power to pronounce a particular judgment that was rendered, lacked inherent power to enter judgment, personal jurisdiction elements. Void order may be attacked either directly or collaterally at any time. Entered in violation of due process, order procured by fraud. A person affected by a void order has the right, as of right, to have it set aside. So let's review to make sure that this court had subject matter jurisdiction and had jurisdiction over the parties. Let's examine the witnesses' testimony, the trial exhibits, the memorandums, and what the applicable law is. So the June 16th order, it appears that from the affidavit of Milt, even the FDA had known that the order was virtually impossible. So let's go further into this. We will see that on June 6, 2003, and that would be nearly 8 years from the time of the June 16th order, that the Listeria rule will be established. We will also see in Dairy Foods magazine on 6/15/2013, today is known Listeria can be controlled but not eliminated in dairy processing plant. So during the disputes with the Food and Drug Administration, what was the applicable law, and was there great dispute of where the law was going to be? So what was the applicable law? So what's intriguing about the Union case is that applicable law, that there's a statute, 21-124.61, that was established in 1987. What's interesting is that there was a federal case regarding that, which the court had ordered that the Food and Drug Administration and the Secretary of Health publish in the Federal Registry and proposed rules pursuant to provisions of 5 U.S. Code 553, which that is the Administrative Procedures Act. Further, we'll see ordered that the defendant's motion be granted so that defendants have a total of 180 days from February 10, 1987 to promulgate a final rule in accordance with the court's memorandum and opinion. So one of the interesting thing is, it appears that that was a conventional civil action. In Union, it appears, or in Union case, it was a preliminary injunction and it's seeking permanent injunctive relief. So in Union's case, the law has not even been settled, and they're using injunction as if asserting that it's a prohibited act. So they had not even come to the final rulemaking. There would be issues that creating the rule that it did, it would create a paramount shift, and there would be multiple statutes that it would conflict with. So there's legal issues that the court did not have jurisdiction to take on a matter, And should the court have that an injunctive relief is not a proper action to take in such a matter. And further, you would raise some issues as the dispute with union. They had left the facility on, I believe it was like December 14th. This action was filed in April 7th. So approximately over 180 days. So you had 6 months before this litigation. And did you submit to public comment, or did they take any action to follow the Administrative Procedures Act? So was there any rulemaking or whatever? So why are they bypassing the regulatory requirements of these rules, particularly when they are in direct conflict with countless things? So wouldn't the court also either say that there needed to be a stay until the final rulemaking body, or dismiss it until the FDA established a rule? So are there legal issues that it would have violated due process and the notice? And also is the rule of lenity if it's unclear of where the law stood? Most disturbingly is that the U.S. Justice Department went into a federal court to seek a permanent injunction. So basically a death sentence to a corporation, and it's going against its own policy that the FDA had created, and that they are apparently rewriting a rule that has not even been written. So is there serious issues of why they would be seeking an injunction? But most disturbingly is on the context that it had. So what was the evidence that they presented to the court? And it appears that they were only presenting one segment of the plant's operations. Are there legal issues regarding that? Additionally, would it be creating a class of people with different rights, privileges, or obligations? Moreover, the FDA is not sanctioned under the U.S. Constitution. So the FDA is having the power to determine rights and privileges and obligation without any rulemaking. So they're basically turning the commerce into a general police state. And further, these are quasi-litigations. So you're apparently sanctioning or preemptively punishing a future event, which we don't know the event or the law that's going to land. So is this totally does the court have jurisdiction to make these type of rulings? And then we want to go even further, is if they're not sanctioned under the Constitution and they're bypassing the Administrative Procedures Act, which is basically the Bill of Rights of someone, is there issues that it's in conflict with United States v. Miller, which was the widespread fear were an intolerable threat to individual liberties, and that they amended the Constitution to remedy that fact. So with obvious purpose to ensure the continuation and rendering the effectiveness of such forces, the declaration and guarantees of the Second Amendment were made, and it must be applied and interpreted in that end in view. So presently, it appears to identify, the General Accounting Office had identified 104 federal civilian law enforcement components or administrative agencies. Are these in conflict with a federally protected right of the Second Amendment? So I believe that there is considerable legal issues if the court had subject matter jurisdiction. So when the FDA claimed in the use of this zero tolerance policy, does it conflict, or do we know exactly that that's where the law stood, which would have then leads to the injunctive? So are there issues that the court did not have subject matter jurisdiction in this matter? Now, most disturbing is the adverse party, the Rule 65 requirement. We'll go further into this. Does it appear that the notice to the adverse party, that it appears that the FDA knowingly placed declarations that were skewed, misrepresented, or flat out were there issues of fraud in the naming of those individuals? Additionally, if the Administrative Procedures Act would be violated, is there issues that the public comment or the notice period, that persons have a right to be heard before an action is taken by the government? About 2 years after the sale of assets to Guggisberg, I was going through the corporate files. I came across the complaint that was I believe, served on my father or the corporation. On page 3, the statement of fact, I noticed that there was some underlining and some writing in the left-hand margin. These paragraphs read, Defendant Dominic F. Gangale is the president of Union Cheese Company. Dominic Gangale is responsible for and has authority over the management and day-to-day operations of Union Cheese, including the methods, manner, and conditions which Union Cheese are manufactured and distributed. He performs his duty at Union Cheese Facility, Marzilli Declaration, paragraphs 3 and 5. And again, on the left-hand margin of that, it states, not me. The paragraph below that, Defendant Annette M. Gangale is second in command at Union Cheese. She is active in and has authority over the management and day-to-day operations of Union Cheese, including the methods, manner, and conditions which Union Cheeses are manufactured and distributed. There's more to that paragraph. I highlighted it underneath it. The footnote of that, the facts in this memorandum are established by the declaration of Joseph M Madden, PhD, Strategic Manager of Biology, Center for Food Safety and Applied Nutrition, Food and Drug Administration, and upon the declaration of John R. Marzilli, Marzilli Declaration, Director of Cincinnati District Office, Food and Drug Administration, and the exhibits attached to it. So under the rules of federal evidence, there's a term called present sense impression. It appears that these paragraphs had been underlined in the writing on the margin would be my father's. So why would those be underlined, and what was my father's first impression when he read those? Those familiar with Union Cheese Company and the structure, there's the shareholders, the chief executive officer, there's a company secretary, plant operations in the office. With regard to my father, he was semi-retired, spent approximately 40% of the time. And we'll see in the litigation that it says at plant is, I believe, and there's legal definitions of what the plant is and what the firm is. I believe there's some misrepresentations. I believe he spends 40% of the time at the firm. We can further examine that he was heavily into the stock market and spent much of his time, a lot of the time doing that, as well as he was a part-time college student and was writing a book, and also spent time on the phone talking with people and whatnot. You'll see that there is no mention of Dale M. Gangale, which was my mother, who worked there 18 plus years. There's legal issues that she has spousal interest in this matter. And you'll see that there's operations and an office. The person in charge of the office was my sister, and she was not to interfere with operations. Additionally, I handled plant operations throughout the approximately 2 years where I was there full time. There was an understanding that I could run things how I wanted them, and if there was any dispute of how those would be between me and my father, that my mother usually was the deciding vote on certain things. So did an inquiry, you'd see that my father very seldom ever went into the facility. And when I say seldom, we're talking several minutes in the last years, probably no more than an hour and a half in the last 5 years. So he very seldom ever goes into the plant. So when you look at these declarations, you'll see, or you'll have some understanding of why those might be underlined and why my sister's would be underlined. So let's go further. So Rule 602, need for personal knowledge. A witness may testify to a matter only if evidence is introduced specific to support the findings that the witness had personal knowledge of the matter. The rule requires the witness who testifies to a fact which can be perceived through the senses must have an opportunity to observe. So with regard to my father, would my father have personal knowledge to testify to facts with regarding to the plant? So it appears that my father testified in this case, and did he have direct personal knowledge to some of the facts that were submitted or discussed within this litigation? Now, the court asserted that it had jurisdiction over the parties. So within this findings of fact, you'll see here Dominic Gangale is is the president and sole shareholder of Union Cheese, with responsibilities for authority over the management and day-to-day operations of Union Cheese. When Mr. Gangale is not present at the plant, defendant Annette Gangale assumes control of operations. So that's a pretty ambiguous paragraph, considering if she's within the office and how you define plant or firm. So Mr. Gangale, if you're discussing firm, it would be Mr. Gangale, and when she's absent or if there's issues within the firm of accounting, sales, or whatnot, there would be that line. However, when you discuss manufacturing, there could be a legal or a complicated issue of what controls he actually had. And are we talking plant? Particulars, I believe, are very important when you examine this paragraph. We'll see when you examine it, it's like you wonder. So when you go back to the statement of facts, the declaration that was submitted before the court, you'll notice that the phrase, including the methods, manners, and conditions in which Union cheeses are manufactured and distributed. Manufacturing would be a significant part when you're examining what individuals. I believe there's issues with the named individuals in this declaration or this litigation. So Antonio Gangale was not mentioned in the statements of fact. It appears to be omitted. And the interesting part is, so Antonio was with the Food and Drug Administration basically the entire time they were within the facility. So there were hours that he's with the Food and Drug Administration. So if you had inquiry into how much time you spent between these individuals, you'd find that Antonio was with them nearly the entire time they were at and even when they were in the office, there was many times that I was with them. So in totality, he's with them enormous amounts of time. And then you'd go into further questions. So what exactly are you litigating? So if you're just presenting issues that are regarding the plant, well, it's possible that he's the sole individual that would be named in this litigation, or that would have direct knowledge of these facts. Further, it's not only Antonio is with the Food and Drug Administration, he's with the U.S. Department of Agriculture and the Ohio Department of Agriculture. And there's immense discussions of where the U.S. policy was going to fall within this matter. So there's discussions with multiple agencies, and it's clear that there was some conflicting within the own federal government of where this policy actually was going to land. Particularly, it didn't make any sense that it would be before the final stage of lethality. So it was appearing that the U.S. Department of Agriculture's position was going to be the proper authority in this matter, the applicable law. And again, it took nearly 8 years for them to come to the final rulemaking on this. So there was considerable issues of where the law was going to be in this matter. Additionally, Antonio was the one that handled the sanitations and knew all of the processes and procedures that was going on in there. Further, Tony would be the one that was having conversations with the sanitation engineers. So they were asking questions of my father that he would have no idea of what actually is transpiring up there. If you examine these declarations and be particular of what each term is, are there issues that the declarations before the court, they materially omitted an individual, and that they knew that there was an issue with that. So when the court asserted that it had authority over the parties, it appears that they only named 2 individuals, and then they also named the corporation. Yet the injunction says defendants Union Cheese Company Corporation, Dominic F. Gangale, Annette M. Gangale, individuals and all the officers, director, agents, representatives, employees, attorneys, heirs, assignants, successors, and any and all persons in active concert or participation with them. So you're giving notice to 2 people, yet you're establishing law and policy that are affecting hundreds of families. Is the union had hundreds of producers and dozens of employees. Is this declaration, is it covering a lot of individuals which would have had, does the Administrative Procedures Act or is there rights to be heard before this litigation is ruled upon? So here you omit Antonio Gangale, who handled the operation and is with the U.S. or the Food and Drug Administration basically the entire time, and possibly the only individual with direct knowledge of numerous matters, 7 days a week for nearly 18 months. He doesn't get named. And then a closely held private business, so the spouse doesn't get notice of what exactly is going on in this litigation. And then you further ask, what the hell is going on? Like, what are you litigating? So there was numerous individuals that should have had an opportunity to weigh in. Additionally, when you think, so that you were paramountly shifting the standards of identity of products, and you were putting zero tolerance on the processing area. So that's not only affecting the dairy industry and not only cheese making, but bottling facilities. So there was a numerous dairy industry stakeholders of how this litigation would occur. But further, if you're attacking dairy industry, well, what makes the difference if it's a dairy or another product with listeria? So is this listeria rule, is it uniformly applied to other industries? So other food industry personnel would wonder if it's before the lethality process, how does it affect their rights? So there's considerable stakeholders in this matter, and here it appears that they skewed or misrepresented the named individuals who had interest in this case. So have no idea exactly what the hell is being litigated or what's going on in this proceeding. So let's examine the declarations of John R. Marzilli. States the FDA prepares official records for these activities in regular course of its business. I am familiar with the investigation of Union Cheese Company, Sugar Creek, Ohio, conducted by the employees of the FDA Cincinnati District Office, official records of the FDA. You gotta wonder is how did Mr. Marzilli come up with his statements of fact within these declarations? It appears that he's saying that I derived them from the official records of the activities in the regular course of the business. So we see here, it says individual, we see that she's named, the title is a secretary. We see it in another document, secretary. We see secretary again. We see owner's daughter. So when we look at this docketing statement in the Northern District Court of Ohio, we see that the complaint is filed on April 7th. On 4/26, there's the answer to the complaint. We see on 5/11, there's a defendant's motion to dismiss defendant Annette M. Gangale, 3 pages. We see that there's 5/11. We see that there is memorandum in opposition by defendant to the plaintiff's motion for preliminary injunction. We see that there's a case management. The FDA will visit defendant's facility and reassess current affairs. Plaintiffs will make investigators available for depositions and will make managers available for depositions. And then we'll see here memorandum by the plaintiff in opposition to defendant's motion for dismiss. So let's again remember that the court asserted it had jurisdiction of the subject matter and of the parties. So we'll see the answer to the complaint for the injunction. Defendant admit Annette M. Gangale is an individual, is the daughter of Dominic F. Gangale, admit she is an employee of Union Cheese, but deny she is second in command at Union Cheese Company, and further state she is not an officer of the corporation and is not in charge of the firm when Mr. Gangale is absent. The oaths of office of justices. I will faithfully and impartially discharge and perform all the duties incumbent upon me under the U.S. Constitution and laws of the United States, so help me God. The judge takes an oath to follow the law. So within an injunction, a court may issue a preliminary injunction only on notice to the adverse party. So was there notice to Antonio Gangale? Would he be party to this action? Further, more disturbing is so they have a case management. Remember, before they can take action, there's that they have to have it over the parties and of the subject matter. So wouldn't there be serious issues at this point where the named individuals? Further, there was federal law of the 60-day aging period. And there's case law where judge required the FDA to comply with the submit it to the Federal Registry in a final rulemaking? Would there be clear issues? What is this dispute regarding? Did the judge have authority? And can they assert this zero tolerance policy? Is it in clear conflict with federal law? And is it conflicting with other state or federal agencies? And is there Fourth Amendment violations here of search and seizure? And is it constitutionally vague? So there was considerable issues in this case conference that should have been addressed, in my belief. It goes even further. The memorandum in support to the motion of preliminary injunction, here it says, defendants have previously served and filed an answer to the complaint for the injunction. So within that answer, it had stated that here we see, in addition, the defendants have filed their motion to dismiss Annette M. Gangale for the action as having been improperly named as a party. That should have been a huge red flag. Here we see in the motion to drop party. Here we see an affidavit submitted by the owner. It says Annette is a secretary and office manager. And isn't that what paperwork and things that the declaration of Marzilli saying that how he derived, isn't that what's within the paperwork? And you have a declaration of the owner. So that's coming directly from the horse's mouth. Wouldn't there be a serious inquiry into who the named parties or what's being litigated in this? And this wouldn't be any rocket science, because you had the ability to go into the facility for 3 days and depose people. So you had access to all these employees. There's independent milk drivers that are in there daily. You had milk co-op going in there. There's whey customers that you have. There's neighbors in community that you could have inquired about. There's further local businesses. Further, you have the U.S. Department of Agriculture going in there, as well as the Ohio Department of Agriculture. And if you wanted, you could examine the business records that are on public record, and you had access to see that the corporate secretary is Dale Gangale. You could have asked her questions and her knowledge. So most remarkably, you see that there's a declaration from Philip, which is undated, and it appears to be after the search. So is his declarations that he put before the court, does he appear to omit Antonio? Imagine that you're litigating something and there's this dispute of a named individual, and the U.S. Justice Department goes to an individual and asks for a declaration or an affidavit of what he's aware of, and he doesn't mention Antonio Gangale. He's with this individual for countless hours. You were there multiple times, one going on 3 weeks, and he's not mentioned. And you are specifically addressing the issue of named individuals, and you appear not to address him or have any question of, hey, they're saying it's not his daughter that handles operations. That you wouldn't say, well, I also work with an Antonio, or hey, I don't know exactly, or maybe I'm confused, or there's some dispute in some of these issues. You don't specifically make sure all this information is correct before you go into a federal court seeking a permanent injunctive relief. It's inconceivable that this was done. And when you place something before the court, is it Rule 11 that you did an inquiry? And do you swear, what is the oath that these witnesses take? Is it the truth, the whole truth, and nothing but the truth, so help you God? Was this the whole truth that he provided to the court? I find it inconceivable that this occurred. So let's again remind ourselves, the findings of fact and conclusion of law is that this judge based opinions on. He's considered the testimony of the witnesses. Well, were the witnesses, did they have direct knowledge? Some of them. It says the trial exhibits. Well, did a named individual not be able to provide exhibits of the sanitation and whatnot? And what exhibits did they provide? We see that the memorandum in support of, on behalf of the parties. So we know the court knew that there was issues of named individuals. Here it says arguments of counsel and the applicable law. So what was the applicable law? when you go over the federal court order of the June 16th order, you'll see it states that Dominic is spending approximately 40% of his time at the plant. Is it at the plant or is it at the firm? So is this materially incorrect or misrepresents fact? Further, it says Dominic Gangale is not present at the plant. Defendant Annette Gangale assumes control of operations. And was she not to interfere within the plant? So is there issues with that? Rule 52, findings and conclusions by the court. Questioning the evidentiary support. A party may later question the sufficiency of evidence supported by the findings. So again, the oaths of office of the justice, if it says they swear that they would follow the law. Here we see the justices should perform the duties of the office fairly, impartially, and diligently. A judge should accord every person who has a legal interest in the proceedings and that person's lawyer a full right to be heard according to law. So did that occur? Are these declarations, or excuse me, is this June 16th order, is it possible? And did the judge actually have subject matter jurisdiction to rule in the manner that it did? And does it conflict with existing federal law? Was this order, was it procured through fraud, misrepresentations, and not applicable law? I believe there's numerous issues of false, misleading, misrepresentations, untrue, inaccurate, and or incorrect facts within this case. I believe the declarations are not true and correct. I believe their expert witness misrepresented facts and a whole list of other things. I believe there's a whole list of legal issues within this case. Due process. In the United States, the right to receive notice before the government deprives an individual of a protected interest is guaranteed, along with the opportunity to be heard. Candor to the tribunal. A lawyer shall not knowingly make a false statement or fact to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Failure to disclose to the tribunal legal authority in the controlling jurisdiction known to lawyer to be directly adverse to the position of the client and not disclose to opposing counsel. Offer evidence that the lawyer knows to be false. A lawyer who represents a client in an adjudicating proceeding who knows that the person intends to engage or is engaging in criminal or fraudulent conduct. Fairness to opposing party and counsel. A lawyer shall not knowingly obstruct another party's access to evidence or unlawfully alter, destroy, or conceal documents or other material having potential evidentiary value. False evidence, counsel, or assist a witness in testifying falsely. Knowingly disobeying an obligation on the rules of tribunal. Misconduct. It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Knowingly assist a judge or judicial officer in conduct that is in a violation of applicable rules of judicial conduct. Within the U.S. Department of Justice, their mission statement, in part, it states, and to ensure fair and impartial administration of justice to all Americans. Deprivation of rights under the color of law. Purpose of Section 242, acts under the color include acts not only done by federal, state, or local officials within the lawful authority, but also acts done by the bounds of the official's lawful authority if the acts were done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting under the color of law with this meaning of the statute includes police officers, prisoner guards, and other law enforcement officials, as well as judges. Full right to be heard. So when I had discovered a lot of these legal issues, I attempted to seek legal counsel. Many attorneys, in fact, none of the attorneys would assist or were interested in taking up the case. Ultimately, I filed a pro se. A void order may be attacked either directly or collaterally at any time. Entered in violation of due process of law, order procured by fraud. Subject matter jurisdiction of elements, jurisdiction over the parties, jurisdiction of the subject matter. So I had filed some pro se filings with the Northern District Court. I filed a petition on 4/18/01. Judge Dan Polster issued a memorandum of opinion. In so, the judge sanctioned me for exercising a First Amendment right to petition, and further adjourned me from filing any new lawsuits or other documents with the court. Is that an extremely harsh sanction? In this matter, did the judge enumerate and discuss all the relevant factors, and was there a right to be heard in this matter? Mulberry v. Madison. The very essence of civil liberty certainly consists of the right of every individual to claim the protection of laws whenever he receives an injury. One of the first duties of government is to afford that protection. It is a general and undisputed rule where there is a legal right, there's also a legal remedy by suit or action at law whenever the right is invaded. Chambers v. Baltimore and Ohio Railroad Company. The right to sue and defend in court is the alternative to force. In an organized society, it is the right conservative of all other rights and lies at the foundation of orderly government. It is one of the highest and most essential privileges of citizenship. It is granted and protected by the federal Constitution. Trope v. Dawes. There may be involved no physical mistreatment, no primitive torture. There is instead the total destruction of the individual status in organized society. It is a form of punishment more primitive than torture, for it destroys the individual's political existence that was centuries in development. In short, has lost the right to have rights. When a federal judge blocks access to the court, is there issues of oppression? Is there malice? Did the court place me in an extremely vulnerable position? And did they inflict irreparable injury? Ultimately, I will have the legal interest within the Sugar Creek brand, as well as convey the rights in the matters of Union Cheese. Further, we will see that there is a third-party motion to vacate, which I was barred access to file within this court while these proceedings were going on. I will ultimately be named as an interested party in this action. When you block access to the federal courts, are there issues of human rights violations? I'd like to thank you for your time. I believe what the United States government did was wrong, and I believe everyone should stand up and state that what they did was wrong. Thank you for your time.